The beauty of the presidential system of government, which we practice here in Nigeria, is the principle of check and balances among the three arms of government, the executive, the legislature, and the judiciary. That principle has come to bear regarding the constitutional crisis trailing the 2022 Electoral Act amendments. The Supreme Court struck out the suits filed by President Muhammadu Buhari and the Attorney General of the Federation and Minister of Justice Abubakar Malami seeking to void Section 84, subsection 12 of the Electoral Act. In an unanimous decision by the seven-man panel led by Justice Mohammed Datijo, the Apex Court held that it lacked the jurisdiction to entertain the suits, which it said amounted to abuse of judicial process. According to the justices, President Muhammadu Buhari is not a proper person to approach the courts with such suits owing to the nature of relief sought. Emeka, this is very interesting. You know, it was so controversial at the time that Section 84, subsection 12, to the extent that this even led to the disenfranchisement of the special delegates and super delegates for the conventions of major political parties, all political parties across. Yes. But right now, the Supreme Court said that, look,
you cannot approbate and reprobate at the same time. Yes, and which is very commendable. See, we discussed that matter here on this table. And the advice to the president was sign, then go back to the round table with the National Assembly on areas.
You know, if you check this judgment, the judgment was saying that immediately Mr. President signed, it was a fait accompli.
Yes, it was.
There was no advisor. The advisor said, okay, while I'm signing, I'm appealing to the National Assembly to take a look at this.
But
the Supreme Court is saying that, no. Immediately you sign, it becomes law.
Yeah, you know, well, in a sense, the president was in a difficult position, in a sense, which was that the delay in signing the Electoral Act was putting the 2023 elections in danger. What it meant was that electioneering activities couldn't take off until that Electoral Act was signed. And we didn't want a situation like that. Nigerians cried out that, no, we didn't want that. So I think it also says a lot about cordiality between the presidents, between the executive and the legislature. Yes, the judiciary is supposed to resolve conflicts between the legislature and
no, don't forget that this same National Assembly, the presidency have enjoyed, you know, a kind of cooperation.
No, that's where I was heading to. You've enjoyed cooperation, cordiality, leading to what? Disaster for many members of the National Assembly who couldn't come back, leading to all of the things we are seeing. The president now going to court over something, you know, over which himself and members of the National Assembly had back and forth. So what kind of cordiality? In whose interest? I mean, what it only shows is that going forward, people should be conscious of the kind of legacy they want to leave behind when pushing forward pieces of legislation. Don't just push forward a bill or an amendment because you want it to favor you. At the end of the day, it could backfire. Like what has happened, it could backfire. And everybody could even lose out, you know, in the long run. So in this case now, I commend the Supreme Court for telling the president clearly that you cannot have your cake and eat it. You have to decide if you are going to leave, if you want to remain as an appointed public officer, remain there. But if you are interested in running for office, then you have to quit within this time specified by the law and move away. You don't just try to stay, you can game the system, take advantage of the system, while those who are out on the field already campaigning and working hard, you want to deprive them.
Oh, I personally like that Section 84, subsection 12. Personally. I personally love it. Like I said earlier, you see, it's a privilege to hold a public position. It's a privilege, it's not a right. Anyone who holds a public position, either by appointment or by election, is only enjoying a privilege. Any Nigerian could be. There are so many Nigerians who can be minister of this and minister of that, who are qualified, who are even more qualified than those who are there now. Now you are an appointed person. You want to become president or governor. The law says resign. You cannot contest why you are holding that position. Okay, it's fine. Then leave it like that. Now, this bill was signed, assented to by the president. And then he had an afterthought. Now, after having an afterthought, he should have had a discussion with the... We also understand the fact that time was going anyway. But going to court couldn't solve it. That judgment by the Supreme Court was very brilliant. One of the most brilliant judgments I've ever read. You assented, Mr. President, you assented to this bill. It became a law. What you assented to, that means you are a party. You are a party to the law. You are part of the law, the lawmaking process. You have said this law is okay. Now it's like you are even bringing yourself to court because you are part of it. It's like you are bringing yourself to the court and you are saying what I did was wrong. So the Supreme Court, by that pronouncement, I love it so much. Maybe tomorrow, maybe in future, that law can be amended. But as it is now, it stands. It stands. You cannot have your cake and eat it. That's what the Supreme Court has said. And so it stands. That's the apex court. The wise men have said it, and that's it.
But actually, I remember when the Attorney General went on his voyage to an Abia High Court to go and seek, he got a judgment, and we said it on the show that this will not stand. And that case was about the fastest and everything. Under 10 days, it was adjudicated upon. The verdict came out, and we said it's going to be appealed. And we predicted that the Supreme Court will not allow this to go. And here we are today.
Yes, I knew at that point that the Attorney General will lose the case. I was very confident that he will lose the case. And what has worsened matters in this case is the fact that the Supreme Court refused to look at the merits of the case. As far as the Supreme Court was concerned, the president had placed his role in putting that act together. The president worked with the Attorney General of the Federation, he worked with the National Assembly, and that act was put together. So having given his assent with his signature passing through the act, it has already become law. The Supreme Court is saying that there is nowhere in the Constitution that it is permitted to step in once the National Assembly and the executive have come up with a law. For one of them to now say that this law is illegal, therefore cancel it. The Supreme Court says it does not have that power. You, as the president, you've given your assent. Once you've given your assent, it has become law. You can't come back and say, no, this law is illegal. A law that you are part of is making. Admittedly, the president expected that they will expunge that portion once it got to them. But the motion was defeated on the floor of the National Assembly because people must understand why that portion came in the first place. It was an attempt to address the extreme advantage that governors have in putting up delegates lists and all that. Some governors have up to 2,000 aides. If that portion had not been introduced, all of those people would be able to come and vote as delegates without being restrained. So they were trying to address that problem and ensure that governors do not have an unfair advantage. So Mr. President thought that by advising them to expunge it, they would listen. But he didn't realize that that particular portion was dear to the hearts of the lawmakers. The lawmakers, having seen what transpired during these world congresses of their parties, they have seen that governors were bent on ensuring that a lot of them do not return to the National Assembly. As we have seen, that has happened. But they were trying to reduce the powers of the governors, reduce the influence of the governors during the season when delegates elect standard bearers of the political parties. So for a governor who had 2,008, if all of them can vote, it's already given the governor a kind of unassailable margin, an unassailable lead, whether the candidate that he has brought is popular or not popular. So that was what they wanted to address. So Mr. President thinking that they will listen to him and have it expunged was a mistake, because on the day that portion, or the day the motion seeking to remove that portion was brought before the Senate, it met with a resounding no. Senator Haliero was the first to get up. And the entire Senate, I didn't hear a single dissenting voice, rose in a wave to say, no, we are not going back to look at this act. So, Mr. President has learned a lesson from this. You can't be too sure that the National Assembly will listen to you when you've already given your assent to a particular law. And the Senate, and the judiciary, the Supreme Court is saying, no, once you have done that, the law does not permit us to come back and undo what you have done. The law does not even permit them, because the National Assembly's duty is to make laws. The judiciary cannot come and stop it from duly making laws. That's part of the argument that these judges have made. The president has no power to declare a law made by the National Assembly illegal, especially when he partook in making that law. In fact, the judgments refer to the Attorney General of the Federation as having participated in making that law. So how do you then come back? That's approbating and reprobating. That's the way the learned men, the Supreme Court led by Justice Datijo, that was the way they looked at it. You can't eat your cake and have it. You've given your assent, it has become law. You have no rights, no power under the law to go back to undo what you have done. And since if they had looked at the merit of the case, maybe the judges will have said, okay, this matter will affect the fundamental rights of some people, but the Supreme Court refused to look at the merit of the case. Remember, even this matter was even wrongly filed in the first place, because the person who filed it in the Abia court could not prove that he was that his rights were taken away by the provisions of that law. You have to be one of the appointees of the government who, by the enacting of that law, has had his rights taken away. He couldn't prove that he was one such person.
Affected.
So he was not, by law, he shouldn't have even filed that case. That is why this particular case was even described as a kind of wasting the time of the court.
Abuse of court
Abuse of the court process. Yes. So that's the thing. It's a lesson for Mr. President. Don't overtrust people that even if they give you assurance that they will fulfill the
That's the beauty of
they allow the
democracy.
president to
Yes,
sign.
yes.
They allow him to sign and refuse to go back.